Well, we're back. Spontaneous, live. I'm Matthew Leffler, the Armchair Attorney. You're listening to the Armchair Attorney podcast, a recording that I do from time to time, breaking down a Supreme Court decision, or oral argument, I should say. The decision is still a little ways away, though I know you are all very, very curious. What do you make of the oral arguments that took place just a little while ago in what is likely the most important Supreme Court decision in transportation right now, specifically for transportation? The issue, of course, is one we've talked about over and 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 over again. That issue, of course, is broker liability. When can a broker be held liable for the negligence of a motor carrier? This has been the question percolating among the federal appellate courts. Finally, today, March 4th, 2026, we had oral arguments in the Montgomery case. The facts are well known at this point, but they follow a similar fact pattern whenever you're talking about broker liability. You have a motor carrier who is selected by a broker to move something by a freight broker. The freight broker had an agreement previously with the shipper to move that particular load, and tragedy strikes. Tragedy always seems to strike when you're talking about the world of transportation and logistics. We just saw Delilah's Law. It's still in the Congress right now. Hopefully we see some activity on that. But that, again, goes back to the idea that there are people out there who are being injured in these trucking-related accidents. And those accidents aren't really slowing down. We've seen them increase over the last couple of years. And that's the issue with broker liability. That's the issue with the Montgomery case. This case came out of appeal from the Seventh Circuit Court of Appeals. That's my neck of the woods, Illinois, Indiana, Wisconsin. C.H. Robinson, who is the respondent in this case, they were the defendant initially. They were successful on appeal. They won at the Seventh Circuit. The question was C.H. Robinson liable for this theory called negligent hiring? So there's two ways you can traditionally find a broker liable when a motor carrier is involved in an accident. The first one is vicarious liability. You actually aren't an independent company from the broker. You're actually an employee of the broker. Just like if you're out driving for your company and you get into an accident on the company's time, your company's responsible. They respondeat superior. We are there. We are jumping in to this question. And so the other way, and this is something that I think we're really tackling at this Montgomery case. I'm getting a lot of text messages. A lot of people are curious about this case for a lot of good reasons. The other question is, okay, if you're not vicariously liable, if that's not your employee, okay, that's fine. What are you? Well, maybe you had a duty to vet the motor carrier and you didn't vet them very well, or you had a process that you deviated from. And now that truck driver is involved with an accident. This is the question of broker liability as we dig into the Montgomery case. Now, look, this is horrifying. Nobody likes any of this stuff. I mean, lawyers aside, we're not necessarily human. We're not necessarily lizards or robots either. But the question is very straightforward. You are on the road. Somehow a truck hits you or you're involved with an accident. And that trucking company is liable for the damages. And we're going to say the trucking company was at fault. But you find out something interesting in our supply chain in the United States, and it's touched on multiple times throughout the oral argument. And that is most motor carriers are woefully underinsured. The liability insurance that a motor carrier is required to have is about $750,000. $750,000. That number seems high, but that was established in the 1980s, which was a little while ago. And it was never adjusted to inflation. And so you have motor carriers that are running around with essentially $1 million of liability insurance. That might cover 2 or 3 days, 3 weeks in the hospital for someone who's injured in a catastrophic accident. And the other piece is the truck driving companies, the motor carriers out there. There's over 500,000 of them in the United States. 6 to 7,000 become part of the supply chain every month. So you have this massive amount of small motor carriers and big motor carriers that are regulated by the FMCSA, the Federal Motor Carrier Safety Administration. And 94% of motor carriers that are running around in the supply chain do not have a safety rating with the FMCSA. What does that mean? That means that there are trucks and trailers on the road right now that are out there running around with 80,000 pounds on our highways that do not have a safety rating with the FMCSA. The vast majority of motor carriers are small. They are very, very small. And they're out there running around and they get involved with accidents. About 5,000 people in America die every single year in truck-related accidents. And so what we have seen happen, what we have seen evolve in the last few years is this growth of going after the broker, saying, well, C.H. Robinson or Echo or ITS or whoever else you can think of, you are making billions of dollars of revenue a year, maybe even billions of dollars of profit a year. And maybe you ought to be the one who's on the hook for the liability. That is what is behind the scenes of all of this. Motor carriers that are not maintained properly, that are underinsured, getting in accidents, and ultimately someone looks and says, who can I go after for the damages? Who is at fault for this catastrophic event? And that's the Montgomery case. As I mentioned, at the Seventh Circuit Court of Appeals, C.H. Robinson, the respondent in this case, was successful. But they asked the Supreme Court, alongside the petitioners, to please look at this case. And look at this case they did. And over the last hour and change, we've had the oral arguments in this case. I've kind of buried the lead. What are my thoughts on this likely outcome for this case? Well, we're going to continue to delay for just another couple minutes. Brokers, according to the TIA, the Transportation Intermediaries Association, move upwards of 300 billion, that's billion with a B, of freight every single year. And that number has increased every single year. Look back 20 years ago, brokers moved 6% of freight. Look at it today, brokers are moving upwards of 30%. Some people say 20, 25, but that 20% to 30% of freight going through brokers is what is happening in the country. The brokers are constantly trying to grow their market share by aggregating capacity. And how do they aggregate that capacity, you may ask? They look at the FMCSA. The Federal Motor Carrier Safety Administration is a governmental agency with about 1,000 or so employees, maybe 300 or 400 investigators, an annual budget of just shy of $1 billion. And with that budget, with those people and with their state counterparts, they are tasked with regulating over 500,000 motor carriers, 25,000 freight brokerages, 4,000 interstate bus companies, and millions of commercial drivers. Now, going into this case, going into today, my initial feeling was C.H. Robinson's going to win this. I can't imagine a world where they don't. For C.H. Robinson, it's not just them who are on the side of brokers not being held liable for the negligence of a motor carrier. It's the U.S. Chamber of Commerce. It is the federal government, the DOT, and the FMCSA. These have all come out very clearly and said, no, 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 no. We do not think brokers should be held liable in these circumstances. On the other side, you have the petitioners, the Montgomery, Sean Montgomery, who was injured, lost his leg in this catastrophic collision. And you also have 29 states, as well as the District of Columbia. So states are coming out and saying, this is a question of federalism. We believe that our state, our citizens, have a private right of action against a motor carrier, as well as the broker. So now you have the sides taking shape. You have the brokers and the brokerage industry, as well as many business organizations. And then you have states, as well as the plaintiff's bar and the petitioners in this case, trying to say brokers should be liable. And it highlights everything that is wrong with American supply chain right now. I say this oftentimes, whether you see me here on Freightways or other places, or even when you see me speaking in person. We have the supply chain that we deserve. This is exactly what was anticipated with deregulation in 1980. Look back, look back for a moment. In 1980, truck drivers were mostly unionized. About 70 to 80%, some say higher, were unionized, working for unionized motor carriers. The regulations, the regulated era, it was not just, how much insurance you should have. You didn't even compete on price. Price was established for every commodity by the federal government. So you essentially petitioned for the right to move a certain commodity in a certain lane, and other people could say, no, we're fine. We don't need this. Think of trucking in the 1970s before deregulation as a utility. Rates were set by the government. There were 18,000 motor carriers who did this. Those days are not here anymore. Those days are far, far gone. In 1980, you didn't really have brokers, maybe a couple hundred they talk about in the oral argument, not moving anywhere near what they're doing today. But today, there's 25,000. Hundreds of billions of dollars are moving through brokers. And brokers wouldn't exist in the fashion that they exist if it wasn't for deregulation in 1980. So, what are we seeing? We are seeing more truck accidents, more fatalities, more injuries, and this expansion of small motor carriers. And these small motor carriers have dubious safety records in some cases, no safety records, and they don't maintain their equipment in some cases. And they're involved with accidents. And so they say, well, shouldn't the broker be responsible? Didn't they put this guy or gal here? If it wasn't for them, wouldn't this accident never have happened? But there's a statute. That's where this thing all boils back to, is this thing called F4A, this federal aviation statute that had a carve out specifically for brokers. It says brokers are responsible for price, route, and service. That's what they do, those three things. And there's a safety exception that says if you're going to get involved with price, route, and service, it's about safety of the motor vehicles. There's this, as it relates to motor vehicles, this entire case revolves around this very small safety exception of whether or not brokers are preempted from being sued. That question had been answered by multiple federal circuits. You get what ends up being a split among the federal appellate courts. On one side, the ones who say brokers should be liable is the Ninth Circuit, which is out west, California, Washington, Oregon, and others. And you also have the Sixth Circuit also saying, yeah, we think brokers ought to be liable for the negligence of a motor carrier. On the opposite side, you have the 11th Circuit and you have the 7th Circuit. So two circuits on each side and more coming every single day. We need clarity. I've written about this topic over and over again. I teach this topic to my law students at Michigan State University College of Law. It's rare that you get this case that goes to the Supreme Court. Now, I have a lot of opinions about how the oral argument went. I want to read through the transcript, and I'll load the transcript as well as the audio recording of the oral arguments to the podcast. You can check that out on your own. But my feeling going in was that the brokers were going to be slam dunk. They're going to win this. I'm not so sure. I'm not so sure because one of the things that we keep finding out, we keep discovering this, is that who bears the cost in a catastrophic accident? If the motor carrier only has the minimum insurance required, they're going to go bankrupt. They're just going to wind down the company and wait a couple months or a couple years and try it again. And they're going to get right back out into moving freight. Is it the brokers? Should the brokers have some skin in the game? Well, some of the questions brought up by the Supreme Court, which many people don't quite understand, is that brokers lack a lot of information about the motor carriers they work with. This is the important thing to keep in mind. And I reiterate this point every opportunity that I get. Small motor carriers do not exist without brokers. They don't. And brokers do not exist without motor carriers, small motor carriers. These two entities are not adversaries, though sometimes they are. The real adversaries of the brokers and the small motor carriers are the big motor carriers, the Werners, the Knight Swifts, all the others. And those companies also have their own brokerages, just to keep everyone on the same side here. If you say that brokers have liability, then certain things have to change. For example, brokers generally don't have information about the individual driving record of a driver moving freight for them. The motor carrier is selected by the broker, and the broker selects the motor carrier, and the motor carrier selects the driver. Brokers generally don't know all the information about the driver, and they're legally prohibited from learning things about the driver. If brokers are going to be held liable, you can bet that the brokers are going to have to know a whole lot more about every trucker that's part of their network of motor carriers. No way around that. Also worth noting, brokers have no legal requirement to carry liability insurance. Many of the very big ones do, but the vast majority of small brokers, all they have is a $75,000 surety bond, a bond that basically says this person or this entity is not going to be, is going to cover the freight costs. They're going to pay the motor carriers. It doesn't talk about the liability of what's happening. So the question that we see in this case, we don't know the answer yet. My feeling remains that the brokers are ultimately going to prevail in this, but it has shown the dark side of the American supply chain. Some fast facts, the key facts that I took away from this entire exercise was one, the Supreme Court and even the FMCSA to an extent recognize that there is a woefully inadequate amount of insurance for motor carriers. If that number of 750 had been tied to inflation when it was first established in the 80s, motor carriers would likely have to have $2 to $3 million of liability insurance. Presumably, that may be a change we see from the federal government, requiring more insurance for motor carriers. But that is one of the ways we can approach it. 94% of all motor carriers that are out there right now, 94% of all motor carriers out there right now do not have a safety rating from the FMCSA, meaning these trucks and trailers, they get applied to at the FMCSA's website, they get their operating authority, and then nobody touches them. Nobody sees them for a long, extended period of time. They try to get some in the first year or 2 years, but one, you can't volunteer for a federal inspection of your truck and trailer. And two, and this leads into my third point, the FMCSA is overworked, understaffed. That's the issue. That is 100% the issue. What you get from this case, yes, there is a fight between the motoring public and the liability risks put on the road by unsafe operators. And we say, who put the operator here? Did the operator come here because of a broker? Did the operator come here because of a shipper? Where did they get here? How do we navigate why they had this accident in the first place? Do we want freight brokers to be guarantors of the performance of the motor carrier? I don't think so. I don't think we do. And the respondents made a very interesting point. If you're a broker and you're really going to get into the weeds on a specific motor carrier, you're going to dive into all of their driver qualification files, which again, you can't do that legally now, but let's say you could do that. You could dive into every little bit of information about that company that you're going to hire. Does that expose you to vicarious liability? Are you controlling them now? Well, if the answer is yes, then now you have a co-employment situation. Now brokers are in big trouble because they're controlling the motor carrier and they're learning more than they need to. If you just simply rely on the federal system, then maybe you're not exercising a good duty of care. Now you're negligently hiring the wrong motor carrier. All of this is fixed. All of this is fixable, not by saying the broker should carry this new burden. And certainly they should carry some level of liability. They should carry some level of liability. But it all goes back to the FMCSA and the folks at the Department of Transportation. You look at the Department of Transportation, the vast majority of those resources go to the airline industry for very, very, very good reasons. We need the airlines to always be working properly as best we can. But trucking is something that we don't spend a ton of time thinking about. Secretary Duffy, Administrator Bars, these folks have shined a new light in the transportation industry. They show us that there are people who are non-domiciled, illegal folks operating commercial vehicles on our roads. We see that. That's true. That's happening now. We see that truck driving schools that are essentially self-certifying that they can put the people in place and get them a valid license and they can follow the rules of the road and are commercial drivers. Thousands of those schools have been shut down in the last few months. But now we look at this new area, the safety of the motor vehicle, the safety of the driver, and when brokers may hold some part of the responsibility. If the FMCSA, the regulatory agency over truck drivers and motor carriers, doesn't have safety information on a motor carrier, how would an independent, privately held business have access to that information? There are so many tools now at your disposal as a broker. You have things like GenLogs, Highway, RMIS, Carrier 411. You go down the list, there's a whole bunch of these things. But the way this works, the way that broker liability works, is not a question of what did you do? That is not the question. The question in broker liability is what else could you have done? Because this accident happened, whether you knew about it or not. Maybe the driver fell asleep, didn't sleep very well the last night and ended up getting to a car accident and kill somebody. What could a broker have done to solve that problem? I don't know. I do not know. But that is the challenge when you allow these claims to say that the broker should have done more. There is no standard. There is no standard to say you've done enough. The fact that an accident took place, you, the broker, are going to be sued. There's no way around this. So here's my as we kind of wrap up this breakdown of this incredible oral argument. And I urge you to listen to it or read any of the number of things me or others have written. Everything that you own, every single thing that you own in your house or that you look at came on a truck. Whether it got delivered to a store and got put on a shelf or got brought to your porch, everything comes on a truck. For high school educated men, driving a commercial vehicle is the most common job in every single state. For getting education, driving a commercial vehicle is the most common job in over 30 states. However, if you look at OSHA data, and I do from time to time, operating a commercial vehicle is the 8th most dangerous job in the entire United States. It's the most common job, and it is one of the most dangerous jobs. And so we have to look to our regulators. And this is the thing that I want people to get motivated by. This case will have many people who are upset. It'll have many people who are very excited. Either way, we have a problem to fix in the American supply chain. We have seen the FMCSA and we have seen the Department of Transportation and we have seen the US president come out and say, we need to fix trucking. We need to focus on who gets to drive on our roads, what kind of training they have, and what kind of insurance they must carry. But we have to do more. The solution for me is multifold. And spoiler, very, very, very unpopular. I am a lawyer. I am a law professor. I have ideas that are wonky from time to time. But if anything this case has shown us is that we need better solutions. We need better opportunities. And so here are some things I think we should talk about as we look forward from the Montgomery case. Whether brokers are liable or not is immaterial to me because ultimately our goal is to get home in the same condition that we left. Safely delivering freight on time and undamaged is difficult even under the best circumstances. It's a tough job. Most common job in the country, one of the most dangerous jobs to boot. We need our regulator to have more funding. If we want safer roads, we need the FMCSA at a minimum, double the budget. Double the budget. That's all you got to do. That's a beginning place. And I think the Administrator Bars and Deputy Administrator Ellison and even Secretary Duffy can get behind that because these accidents are not going to stop simply by making new rules or the Supreme Court opining that brokers are going to be liable. You have to do something on the regulatory side to put more boots on the ground. There is nothing that motivates the American public more than the threat of great bodily harm. And that's what we're seeing on the roadways today. Again, 5,000 people die every year in truck-related accidents. And yet, the vast majority of motor carriers are underinsured. So when that accident does happen, you know who's left holding the bag? You, me. We pay for this. Those folks go to the hospital. They go to care. They're not being denied. But the motor carrier who caused it is gone. Toast. They're out of here. The other thing, and the FMCSA, I think, generally agrees with me, I hope they do, is increasing the minimum liability insurance for motor carriers. We talk endlessly about how there are too many motor carriers, too many trucking companies in the United States. There are a lot because the barriers to enter are so low. Small insurance, small fees, ultimately more meat for the grinder. You have to have higher rates of insurance. Maybe it's 1.5 million, maybe it's 2 million, but motor carriers are in the best position to insure against the risk that they create on the highway. No other way around that. Has to happen. Now, those are incredibly unpopular opinions to increase the budget of a federal agency and to increase the minimum liability insurance for a motor carrier. Those two things would be likely disastrous for a large segment of motor carriers who right now are struggling to stay solvent. This has been 3 years of the most protracted reduction in volume for transportation in a long time. Many companies are just white knuckling it, hoping that they can make it one more pay period and keep the trucks moving. Things like this, I don't know what happens. So what happens in the next 6 months? We don't know. We should see we have a pretty good understanding based on the oral arguments today, but we're going to find out ultimately where this case will go. If brokers are found to be liable or could be liable for negligent hiring, that likely means that brokers are going to need a lot more power to audit motor carriers. It still probably means we need to increase the FMCSA's budget. It still does. That doesn't go away. You still need regulators inspecting and auditing the trucking companies out there. But it might change the dynamics. The large brokers or brokers of any size are going to likely defer or move away from small motor carriers. They're going to go to companies that have more insurance, more records on the FMCSA, and able to absorb one of these catastrophic liability verdicts. That's going to happen. if you see brokers being held liable. It's also going to mean that brokers are likely going to be required to carry insurance for auto liability, which again, there's no statutory requirement that they do. But if you're going to be essentially a guarantor or strictly liable for negligently hiring a motor carrier, if there's an accident that motor carrier causes, that's going to have to change how you approach the business. If, on the other hand, the brokers are successful and C.H. Robinson, the respondents, TIA, the U.S. Chamber of Commerce, and so many others are going to say it's back to business as usual, that shouldn't sit well with you either. Why would it? Why would anybody coming from a place of what would be the ideal supply chain looking at what we have and go, oh, that's what you have? Did you know that 1 in 5 commercial vehicles are unsafe at any speed? Meaning those trucks and trailers moving your freight right now, if you stopped them and looked at them and inspected them, they would not meet the minimum safety standards the government has set. 1 in 5. 22% is the national out of service rate. Can you think of any other industry on the planet where an 80% success for the equipment is okay? Where you're okay that 1 in 5 are unsafe? I use this example, and I love this example. Imagine I'm a grocery store and I have 5 gallons of milk. And I say, I got 5 gallons of milk. Unfortunately, one of them is unsafe. You'd say, Matt, which one's the unsafe one? And I'd say, I don't know. Then you'd say, well, maybe I would prefer not to buy milk from you. And that's a reasonable thing to say. I think that's probably a reasonable thing to say. It doesn't matter. That's not the choice you have in the American supply chain. The American supply chain is like this by design. The goal of deregulation in 1980 was to remove up to $8 billion of cost in moving goods. Under the regulated era, things cost between 40 to 60% more than they ought to cost when you look at an open market, free market, where people can bid on these things. So you wouldn't want to go back. You wouldn't want to go back to a regulated era. What you would want to do is look at a deregulated era and try to find a way to make this make sense. So all of this is to say, the oral arguments were interesting. I think great points were brought up by both sides. I still feel ultimately that the law that's in F4A does not allow brokers to be held responsible for negligent hiring. If it goes that way, and I think it will, if it goes that way, do not despair. Laws can change. Like, that's the thing people kind of forget. The Supreme Court opines on existing law. They're not generally creating new law. And so if we come to a conclusion, the majority of Americans say, I don't like this. I think it should be different. You can pass a law. You can get a bill proposed. You can get traction. Trust me, there's plenty of organizations that are likely to push for this regardless of the outcome we see at the Supreme Court. But if you're concerned about safely delivering freight on time and undamaged, and if you're watching this, you probably are. Why else would you do that? Then you have to look at the practical problems that our supply chain has. Again, there are 500,000, maybe 600 or 700,000 interstate motor carriers in the United States. 5,000 to 6,000 are added every single month, more and more and more. And you look at our regulator, the FMCSA, and they are playing whack-a-mole, whack-a-mole, whack-a-mole against every single problem that pops up. They are not, at this moment, able to proactively say, we're going to get all of these motor carriers inspected at this point. Like, it's not happening. 94% of motor carriers have no safety rating. So at a minimum, we as Americans should be advocating for a bigger budget and more resources for the regulator that tries to keep, what is it? The Federal Motor Carrier Safety Administration? Seems like that would be right up their alley. And ultimately, there will likely need to be legislation. And that legislation is likely going to require insurance to be higher for motor carriers. There's no way around this. These accidents are not slowing down. And we live in the most distracted society that has ever existed. You go down the highway, I guarantee you are seeing people on their cell phones as they're driving. Sometimes they're truck drivers. We need more insurance for these people. $750,000 is not enough. It is simply, as the court said, woefully inadequate. So that is my hot takes on the Montgomery case, Supreme Court decision, probably sometime in June-ish, maybe sooner. I don't know. They move at the pace that they move. We won't find that answer out for a moment. But it's incredible to see the Supreme Court take up a case that revolves around transportation. The industry has profoundly changed in the last 46 years, from 18,000 trucking companies, heavily unionized, to a time when there's hundreds of thousands of trucking companies, and the unions are all but destroyed, except for a handful of motor carriers like UPS and T-Force and ABF and others. We get the supply chain we deserve. Do we deserve this? We do. These are the decisions made by people a long time ago, and these consequences were generally foreseeable. But when you want to deregulate an industry, you never know exactly how far the pendulum will swing, but the pendulum has swung. Now we will find an answer to this case, and this will answer the cases for thousands of families across this country who have lost a loved one in an accident resulting from a motor carrier who behaved badly and a broker who contracted that motor carrier. No one wins in these cases. Maybe the lawyers. The lawyers might win, but no one really wins. No one's cheering or championing for the destruction or the death of an American. No one wants any of that. But when you create an environment where the regulator has their hands tied behind their back, they can't assess fines, for example, and you have motor carriers that are underinsured, and everyone's competing as hard as they can on price, what more would you expect? What more could you expect? What would you rather see happen? And so that's the kind of conclusion of our conversation today. I really hope you've been following this case. It's fascinating. It really, truly is an interesting time to be alive. And this Supreme Court case will answer a lot of questions, but I don't know that it provides the solutions we ultimately want to see. We're getting close on time. So we'll probably add more in the days and weeks to come on this case. But for fast reactions, I think this kind of gets us a pretty good understanding of where the court is likely to go. My feeling as of right now is 5-4, maybe 6-3 in favor of C.H. Robinson, with the Montgomery family not being able to recover from CH. As we mentioned, the motor carrier is dead and gone. They went bankrupt pretty quickly after all this. These are real lives that are being lost, people being injured. And if you accept that as the inevitable nature of the supply chain, I don't think so. Does this push for robots, autonomous trucks? Maybe. But if we have seen anything about the current U.S. administration, it is that they do take vehicle safety and trucking generally as a really important issue. And this is the case that highlights everything that is problematic with this particular lawsuit. We see motor carriers that are poorly maintained, motor carriers that are underinsured, a regulator that is overworked and underfunded. Brokers and motor carriers are working on price, route, and service, the travel agent of the freight, as it were. And yet we still look and say, who should be responsible? Who is the one that carries the bag when someone dies? Obviously, the motor carrier and the driver, but if they are underinsured, they're gone. They're no longer there. Who else can you go for? Well, if C.H. Robinson and the respondents are successful, you won't be going after the brokers, and you're right back where you were before, which is we need to have better regulation enforcement, higher rates of insurance, and maybe an out-of-service rate that's 15% as opposed to 22%. It's a tough question. It's a really tough question. No one anticipated brokers would capture 30% of the marketplace. No one thought that was possible. But remember, the small motor carrier needs the broker, and the broker needs the small motor carrier. If you don't have them working together, they will not be able to compete with the big motor carriers. And in 1980, it was really about big motor carriers. Today, it's not as much about the big motor carriers. But if you change the dynamic, you change the regulatory framework, maybe it does. And so as I wrap up, I would say once again, this case will not solve the safety issue in the supply chain. Let me repeat that. The Montgomery case will not solve the safety issues in the supply chain. It simply holds another entity accountable for when somebody does something terrible. Maybe that changes how we think about the supply chain, but what it really shows us is what was brought out during the oral arguments. The FMCSA is overworked and underfunded. Fact. Motor carriers are woefully underinsured. Fact. And ultimately, if we want to see some sort of change, those two issues have to be tackled. You have to have more resources for the regulator who says when trucks and trailers and motor carriers are safe or unsafe. Putting that into the broker's hands and saying, broker, you're in charge of telling us if this motor carrier is safe, opens up a Pandora's box of motor carriers having to tell way more information about their drivers to brokers. Maybe that's a good thing. Maybe it's not. That's it. We did it. That is our breakdown of the Montgomery case. I really enjoyed this one. We never know who's listening or why they listen or what value this is designed to do. I love transportation. I'm a lawyer. I'm a podcaster. I'm a consultant. But really, I'm a transportation enthusiast. Nothing gets me more excited than people safely delivering freight on time and undamaged. My dad worked for Roadway back in the 70s and 80s. Started his own company, fixing commercial vehicles. That's why I love maintenance. I love well-maintained equipment. No one appreciates that as much as yours truly, though I suspect if you thought a lot about it, you'd want those trucks and trailers to be safe as well. Broker liability. A lot of questions, not a lot of answers. Time will tell where SCOTUS lands. Catch you next time.